For this Sanko video clip, we welcome Christina, who's kindly agreed to tell us about two newly agreed proposals, one for alternative dispute resolution and another for online dispute resolution. So Christina, welcome. Thanks for taking the time to talk to us. Firstly, what exactly is alternative dispute resolution?
Thank you, Paul. I'm very happy to be here with you and to explain about alternative dispute resolution, which actually means any kind of system to have a quick solution for consumer disputes out of court. So it's out of court system of solving consumer disputes. It is something important for consumer because it gives a way to solve quickly, effectively, and at a very low cost consumer disputes.
And you hope that this will encourage consumers to participate more in the single market by shopping across borders?
Yes, because consumers will have an easy way to get redress, which is not the case now in all the member states and in all the sectors. ADRs, as we call alternative dispute resolutions systems, exist in some member states, in some sectors only. And by the full coverage that this directive should ensure, consumers will know that they have an easy mechanism to get redress, and therefore they will be more encouraged to shop, they will be more confident in the single market, and we think that this will boost the growth of Europe in general terms.
So this initiative is purely cross-border?
No, we have to understand that with the alternative dispute resolution, we want that all member states in all sectors establish an alternative dispute resolution system to which a consumer can refer in order to deal with her or his problem. And this is also cross-border, but not only. Our proposal, which it was a bit difficult to build, but we managed, not only ensures the internal market dimension, but also the consumer protection dimension within the member state. Let's say, for example, in Belgium, there will be the need to establish alternative dispute resolutions entities where they do not exist, and they can also serve a Belgian consumer for a transaction with Belgium. But then comes the online dispute resolution proposals, which adds something more, and this is focused on cross-border online transaction. In order to promote the digital agenda, in order to promote e-commerce and the cross-border dimension of e-commerce, we will set up an online dispute resolution platform to which a consumer can address directly for any dispute which is linked to a cross-border e-commerce transaction.
So this whole process would take place entirely online?
Yes, it will take place entirely online. Consumers and traders can develop all the procedure online, including all the contacts with the national ADR to which the platform will refer the consumer and the traders for the actual solving of the dispute.
Well, while I can see a big attraction for consumers to want to get involved with this kind of process, I mean, the advantages are obvious. What's the incentive for businesses to get involved? Is it likely that some might be, reluctant to go down this route?
No, business in fact are very much of demander of these proposals because business are very keen in having an easy way to solve disputes with consumers, because it is good for business to be able to keep their reputation without paying the high price of going to court for any kind of small dispute.
And finally, a question that intrigues me. One proposal for ODR is for a regulation, and for ADR it's for a directive. Why the difference?
That's a good question, and there is a good reason for that. It is that the proposal for the directive on ADR, it is a framework directive, because as I said at the beginning, in member states already exist some ADRs, and we do not want to have an ADR entity established at the EU level which would substitute what exists and functions in member states. So with our ADR proposal, directive, we want to fill the gaps and have ADRs where they do not exist in the member states and in the sectors that do not exist. So it cannot, we leave to member states, as it is the case for directives, the way to reach the objectives which are fixed by the directive.
Mhm.
Whereas with the regulation has to be taken like that because it aims at establishing this ODR platform, and the member states have to transpose it without the margin of maneuver that the directive leaves in order to see how you can accomplish the objectives.
Christina, thank you very much.
You're welcome. Last thing that I want to say is that these two proposals fall within the Single Market Act. So in principle, they will have to be fast-tracked by the Council and the Parliament. And so we really hope that they will be adopted by the co-legislator by the end of 2012. Thank you.
Well, we wish you well on their legislative journey. Thanks again.
Thanks.
Thank you.